All right, I will start to give an introduction and thank you again for joining us today. This is the Crowdfunding 102 webinar. We're going to be talking about avoiding basically legal problems during and after your regulation crowdfunding campaign. Now, last webinar, we did cover some of the different things to think about in terms of legal issues and accounting requirements and everything else going into your crowdfunding offering. So we can share a link to that after with the recording of this. But today we're going to be focusing on the during and after. And we have an amazing panel of experts joining us. Now, real quick, a little bit about the organization that is putting on this event today. It is the Crowdfunding Professional Association. So myself and a few of the other panelists and people that you will be seeing here are on the board of directors for the Crowdfunding Professional Association. And the CfPA's mission is really to foster growth in the regulated investment crowdfunding industry. We do this through supporting everyone from the issuers to the investors, talking to the platforms, everyone in between, service providers. And we're really working as a volunteer board and a volunteer organization to help to grow everything in this economy, in this industry. Now, if you want to learn more and to be able to see some of the benefits of joining as a member, feel free to go to cfpa.org/join, and you can learn more information there. But the focus of today is really around some great discussion. And before we jump into that, I want to give a huge thank you and a quick introduction to the sponsor of today's webinar. The sponsor is the SuperCrowd, and we have here the CEO and founder of the SuperCrowd, Inc., Devin Thorpe, to say a few words. So Devin?
Brian, thank you very much. I appreciate the opportunity to share for a minute. And I want to just take a minute to tell people a little bit about our crowdfunding that's going on right now. There's a huge problem in the impact crowdfunding space that we serve, and that is that there are too few people doing it, right? Last year, we think there were about 100,000 people. That's certainly right in terms of orders of magnitude that invested for impact via crowdfunding. We think that number should be 10 million by 2032. Now, to get there, we're going to have to put a bend in the curve. We're not going to get there organically or natively. And so that's what we're working on at the SuperCrowd. The value we create for ourselves in this process is by hosting events that we can charge admission to and charge sponsors for helping us to host. So we can make a little profit even as we are serving as a key catalyst for growing this community of impact crowdfunders. Collaboration is our founding principle. For SuperCrowd 22 and SuperCrowd 23, we had dozens of organizations serve as co-hosts and sponsors for the event, and we had over 100 speakers. This was a massive collaborative effort, and our crowdfunding campaign serves as a catalyst for further collaboration, aligning interests among all of those who choose to participate as investors. We're growing quickly already. Our SuperCrowd 23 revenue was more than 65% greater than our SuperCrowd 22 revenue. And going forward, we can not only grow the revenue at that annual virtual event, but of course, we can hold more events. We'll be holding monthly webinars. We'll be holding local events around the country. Eventually, we envision a time 10 years from now when we do 100 events around the country. There is tremendous opportunities for growth, and that manifests in real revenue, right? We can see ourselves growing tenfold from 2023 over just the next 5 years. So there's an opportunity to participate in the economics we're creating. So I invite you all to visit invest.devin.today to learn more. Thanks, Brian. I'll turn it back to you.
Great. Thank you, Devin, very much. And again, this webinar would not be possible without sponsors like Devin and the SuperCrowd. And we're going to be doing a lot more free webinars as an organization. So make sure if anyone here is interested or that's watching this, feel free to reach out to us at info@cfpa.org and we can give more information. But everyone is here today for the amazing panel of experts and the moderators that we have here with us today. So what I'm going to do is give a quick introduction to the moderator of today's panel. Peter Rostovsky is the moderator, and he's the founder and CEO of Raiseway. They help potential issuers raise capital. I'm sure he can give a kind of a quick introduction, a little bit more himself, but Peter is also an esteemed director as well at the board of the CfPA, and he's held various roles in the capital funding and crowdfunding ecosystems. So you have an amazing moderator for today's panel. I'll turn things over to Peter, and he can introduce your panelists to you. Peter.
Thank you so much, Brian. Thank you, Devin, for sponsoring this event. For anyone joining us who is interested in the first part of the crowdfunding process, so when you're, figuring out what goes into Form C and figuring out the accounting compliance, please watch the YouTube video, Crowdfunding 101, Legal Issues with Legal Compliance. We'll put a link later under the description of this video. But this conversation will be focusing on things that happen after you've made a decision to raise money on with investment crowdfunding. And today we're joined by Jenny Casson, capital raising coach, attorney at the Casson Group, Peyton Theodore, Chief Operating Officer at LawCloud, and Mark Roderick, Principal Partner at Lex Nova Law. I hope that the panelists will say a few words about their work and about what they focus on, and then we'll jump right into the discussion. I think we could start with Peyton. It's very nice to meet you. We haven't spoken before. Would love to learn about your work, what you do at LawCloud.
Yeah, great to meet you as well, Peter. At LawCloud, we offer a software to help platforms and founders and lawyers create drafts of forms that are filed with the SEC. So we do everything from the Form ID to the Form C, a PPM for Reg D offerings, Form 1A for Reg A. And we are very much fans of compliance and like to support founders really from the start to the finish. So one of the things we also offer is Form CAR, which is the annual report that's due every year. And that's pretty much it in a nutshell.
Very interesting. I'm sure we're going to cover quite a bit of the Form CAR question, because I didn't even know what that was called. So that's very useful. Mark, a pleasure to meet you. Could you share a little bit about your experience as well?
Well, yes. As I always say, I'm just a boring corporate lawyer. I happened to get into the crowdfunding space before it was born, way back when, and have been involved ever since. I write a, very widely read crowdfunding blog, a lot of stuff called crowdfundingattorney.com, and I knew of LawCloud. I knew of the principles of LawCloud even before LawCloud existed, just to show how far back. It's a small world, right? Everyone knows everyone. But I mean, the most important thing, I guess I should say, is that I am evangelical about crowdfunding and always have been, because of the opportunities it presents, not only to get capital where capital has never gone before, Minnesota, for example, but also
I think for most people in this industry, it's ideological.
But also to provide ordinary Americans with investment opportunities that have hitherto been reserved for the very wealthy. So yeah, so that's what I've been doing all these years. Thank you.
Thank you for being here, Mark. And Jenny. Jenny is not only all the things I mentioned before, but she's also a director at the CfPA and secretary of the board. So Jenny, it would be great if you introduce yourself as well.
Yes, thank you. So I worked at a nonprofit after law school, and one of my jobs was to support the small businesses in a low-income community. And I just became really passionate about solving the problem of lack of access to capital by the vast majority of businesses in our country. And I ended up becoming a securities lawyer in 2006. And I had a lot to learn. but I learned everything I could about securities law and helped clients raise money using what we used to call a direct public offering, where we would do state level registrations, use some federal exemption. And then in 2010, I worked with some other advocates to write a letter to a petition to the Securities and Exchange Commission to ask for an exemption, because it just seemed crazy to me that even if you were investing a very small amount, there was no easy way for a regular person to invest in a small business they loved. Yes, we could do these state level registrations, but it was a very challenging process. So we wrote the petition to ask if we could possibly get an exemption where people didn't invest more than $100. And strangely enough, that kind of took off. The SEC completely ignored it, but Congress and the White House paid attention, and a lot of advocates took on the cause. And amazingly enough, in 2012, we got the Jobs Act. So I, have been practicing as a securities lawyer for, people who wanted to raise money from their community since 2006. I'm happy that we have some new tools, but it's challenging. And I'm excited to talk about all the things that folks need to do it right.
Yeah, well, thank you, Jenny. And it's an honor to be here with veterans of the industry. That I'm admittedly very new to it. So I wanted to start our discussion with just around I guess the time frame of the campaign where we left off our previous conversation, which is the testing the waters disclaimer, right? So before you go live with a campaign for the entire world to see, you can start testing the waters process, and it would be fantastic if any of the participants were willing to share their thoughts about how to do so compliantly, how to not, mess up your campaign even before it starts, essentially. So who'd like to take this first?
I can take that. So when the rules initially went into effect, it was really awkward because there really was no legal way to tell people that you were planning to do crowdfunding until you actually went through this whole process of filing your compliance documents. And so the good news is there was this update where you are now allowed to do this thing called testing the waters, where you let people know that you're planning to do crowdfunding. You do need to include certain disclaimers and make it clear you're not accepting commitments at this time. One thing, though, that I do want to mention that is really frustrating about some of the new rules that have come out, and I don't think it's necessarily a change, but it is something that you have to be really careful about. And that is that the SEC made it clear recently that if you publicly advertise even the possibility of doing a securities offering, and you get people interested and committed, and not committed, but signing up on an interest list, and then you change your mind and you decide to do a private offering, all of those people that heard about the fact that you were raising money via a public offering, you cannot invite them to invest via a private offering because they're considered to have been solicited publicly. So I just love to tell people, if you do testing the waters under regulation crowdfunding, make sure you really do plan to do regulation crowdfunding, because if you change your mind and switch to a private offering, it really can mess you up.
Is there like a time frame in which let's say
I wrote a letter to the SEC. I think it was the CfPA that wrote the letter, that signed the letter saying, please give us some time frame, maybe a year. Nope, no time frame. It's forever. But the only way you can solve that problem is if you develop a relationship with those people. So, have them on your list, become friends with them, don't talk to them about investing. And then hopefully after you've gotten to know them a bit, maybe, a little ways down the road, you could include them because you've converted them into people that you have a relationship with. They're not just people who heard about the offering via public advertising. But yeah, we were not able to get the SEC to give us any time limit on that.
I
So
see. Well,
let
thank
me
you,
just say
Jenny.
a couple. So they
Right.
could, if they're accredited, they could obviously participate in your Rule 506C offering.
That's correct. And once you do public, you have to keep people in that
You have to
public.
keep public. And on the developing a relationship thing, I mean, you can't develop a relationship after you've started your private offering. I guess that's the other thing, Jenny, that you are fully aware of and try to convince the SEC. So you can't say, oh, now I'm going to do a 506B offering. Now I'll cultivate a relationship with these people. That it just doesn't work that way, which seems like a bunch of silly hoops, right? To have to jump through. But there you go. That's an excellent point.
So you can't, so am I understanding correctly that, okay, let's say that I was considering testing the waters and then I'm no longer considering testing the waters. No amount of time that passes between that process and me doing a Reg D, and no amount of relationship building.
No.
Like basically,
no,
like
you can, as Jenny's saying, you can build a relationship as long as you do it before you begin your Rule 506B offering.
Right.
Or
and what would constitute as a relationship?
Like 504 offering, any private offering. Yeah. Question.
What concept that? Yeah, that's great. That's a great question.
I've spent a very long time looking at this question online because these very same questions were pertinent to our race.
There's a very well-known no action letter that kind of gives the most concrete advice that we lawyers can give. But the SEC stresses it's not a length of time, it's a quality of the relationship. But it kind of boils down, correct me or add in anyone, if the person fills out a questionnaire and you have a couple phone calls, you're in a relationship. So that, I think,
all right.
Do you want to add anything to that, Jenny?
Yeah, it is a bit of a gray area. I know I've looked at it also under California law. There are some cases that kind of describe it. The way I've heard it described is the person knows you well enough to know your character and your business acumen. So whatever that means.
All right. Nice.
But yeah, you really, if you're developing the relationship kind of with the intention of eventually making a securities offering, that's probably not going to work. So it's kind of a mess because obviously you probably are doing that. So you kind of have to really put your capital raising on hold while you develop those relationships. And then once the relationships are developed, then you can start thinking about raising money again. That's my conservative opinion on that.
Okay, we have a question in the chat. So Jackie Logan is asking, when you're testing the waters, can you mix potential terms and story together off a platform? Mark, Jenny, Peyton?
Can you repeat the question?
Of course. When you're testing the waters, can you mix potential terms and story together off a platform?
Yeah, there really aren't a lot of limits on what you can say when you're testing the waters, unlike once you're actually raising where there are a lot of limits. So it's kind of nice. You can kind of say whatever you want as long as it's not fraudulent and as long as you include those disclaimers.
And I think to her question, you could say it anywhere you want. I think she's asking, can you only say it on the funding portal platform? And the answer is no, you can say it anywhere. You just have to include the magic language about this is only a solicitation of interest and don't send money. And if you do, we'll send it back.
And I guess the follow-up question to this is, at what point can you declare that you're testing the waters? Do you have to be on the funding portal for that?
You are by definition testing the waters until you formally launch your offering.
Once you start telling people that you're you're still, you're, you know, telling the world that you're thinking about doing a crowdfunding campaign, you are testing the waters.
I see. And in terms of the marketing that can go out, let's say that, well, you know, I have a company. If we were raising money with crowdfunding, would I be able to go on Instagram and put a disclaimer at the head of a post or of a, you know, video message or whatever, and it's all fair game? I can speak about the company.
Yeah.
Very
Yeah,
cool.
I mean,
All right.
don't forget that the testing the waters materials have to be included in the Form C when it gets filed. So, you know, you don't want to make like a lot of promises you can't keep in the testing waters. You know, you don't want to say guaranteed 18% return.
Yeah.
And then,
Right,
well, I was
right.
just testing waters. Just kidding, folks. You know, that's not going to work. So,
I see. Okay, and that gets us to the conversation about marketing assets when you're actually live. So you've tested the waters. You are optimistic about the course of your campaign, and then when you launch, you're going to have a good amount of investors come in on day one or in the first week. Am I understanding correctly that you have to prepare all of the marketing assets that will go out during the campaign when filing Form C?
not exactly. I will say the advertising rules around Reg CF, I think, are the craziest part of the Reg CF rules. So let me just, and if you are feeling, if any member of your audience is feeling hopelessly confused about them, you know, join the crowd. They don't make intuitive sense. And I have urged the SEC to change them, but amazingly, the SEC did not follow my advice. So the concept, just to try to make it make sense, is that all investors should have access to exactly the same information. That's the concept. And therefore, the SEC says, the SEC wants everything to be on the portal. And so they try to limit what you can say outside the portal. And they've come up with these 6 things, the 6 deadly sins, that if you say any of these 6 things in an advertisement that's not on the portal, then you can't say anything else except name, rank, social security number, name of the company, what our business is. If you say any of those 6 things, and why those 6 things, the commissioner only knows. Whereas if you don't say any of those 6 things, you can say anything you want off the portal. So if you don't say
This is
them,
a great
you can talk,
clickbait title. Things you cannot say.
yeah, it's the truth. And you don't say those 6 things. You can talk about the company and its prospects and its CEO and its CFO and everything's wonderful and this is our market. Anything you want off the platform. But if you mention, oh, by the way, we're trying to raise $1 million, then you can't say any of those things. It's a crazy rule, but you don't have to decide on all your marketing up front. If by that, what should be the case is anything you say in your marketing should be in your Form C. There shouldn't be any important information that you're putting on Instagram that investors at the portal don't see. So that's the kind of summary, but now I'm going to shut up and let other people.
Yeah, those 6 things. I mean, that's I concur with Brian's comment. What are those 6 things?
And bizarrely, they added 2 more.
Yeah, there were 4.
And they kind of acted like they were doing us a favor by adding 2 more. Yeah, and I will just add, as we get into what those 6 things are, I will also add that if you put, to the extent you put things up on your page, like a video, and materials like that, you know, marketing materials up on your page, that you do want to also file that as part of your Form C disclosures. Even possibly people do, I think that, I'm not sure this is totally practiced by everyone, but we have our clients do transcripts of videos and file that as part of the Form C as well. So, so those marketing materials that you put up on the page, you would want to file as part of your Form C. And then, yeah, what are the 6 things? It's what is it that you're offering? You know, is it equity? Is it debt? You cannot mention that. Yeah, help me out.
Okay,
Yeah, sorry,
mean, when
didn't
I
mean to
say-
make this.
when I
Yeah.
say I'm a boring corporate lawyer, the fact that, you know, I know things like that, it just makes you so popular at a cocktail party. So let's just think of them, Jenny. They're how much you're trying to raise. They're the type of security you're offering. They're
The
the price,
deadline for the rate.
of your offering, the
Mhm.
deadline,
Mhm.
and
What you're using the money for.
what you're using the money for, and one other thing, what did I forget? The price of the offering, the total that you're trying to raise.
I think we
Did
said
I already
that.
say that? All right,
Yeah, well,
okay,
I'll take a quick look while other folks.
yeah,
are
that's what I'm gonna do. But that's the idea. Let's say, anything about the
Right.
technical details of the offering.
That just sends shivers down my spine, to be honest with you.
But you can talk about the company. If you don't say any of those 6 things, you can talk about the company all you want.
What if, I mean, the part about what you intend to spend money on? Let's say that I go on LinkedIn and I say, when we raise money, I want to hire a developer. Is that a no-no?
So you can say it, but what we do is we call it terms and non-terms communication. So if you mention one of those 6 things, that's a terms communication. And so so you can do that, but in that communication, you can't give a lot of other detail about your company. If you want to give more detail about your company, you don't want to mention the terms. Oh, there's Brian got it. Awesome. So,
All right.
yeah, 4 and 6 are kind of the same thing. I think that's why we forgot the 6.
Mm-hmm. Okay, that is, I think that's, if we ever cut this into a TikTok video, this needs to be there. So I wanted to jump to
We might wonder,
the
should
next
we
question.
read them? Because, you know, people
Let's read them.
who wants to read them?
Jenny, go ahead.
Okay, I'll go ahead. Okay, so the 6 things that are considered terms are the type of security being offered, how much you're raising, the deadline for your raise, the price of your offering, which is kind of similar to how much you're raising, what you're using the money for, and the amount of securities being offered, which again is very similar to how much you're trying to raise. So 3 of them are all similar to each other.
All right, now there's 22 of us in this room. We'll go out to the world and spread this word. So the next question I wanted to jump into and to address this to Peyton. So over the course of the raise, let's say that somebody raises money and something changes in their company, right? A material change happens. It would, I'd love to hear what you think about what happens in the process of informing the investors about the material change, how that process goes, and what constitutes material change. And of course, same question goes to Jenny and Mark as well, but we haven't heard from you, Peyton, so I would love to hear it.
Sure. Yeah, I'll jump in, and I will rely on Jenny and Mark to answer the more technical questions, which is what we do at LawCloud. We are not lawyers. We have a network of securities attorneys that we rely on heavily. Where we do come in and benefit people is we offer a concierge service. So we have a team of paralegals. as we're uncovering today, there's so much information, and it's such a niche market that it's not information that the average person will understand. So Mark says he's boring. I love to geek out and listen to what he has to say, because if you're in the industry, you really need to know it and understand it. So in our system, we offer the CU, which is the progress update that you want to offer if you have material changes in your offering. So if someone's going to file that, they would just come back into their dashboard on LawCloud and send the quick update, make it filed with the SEC. But I'll let the attorneys talk about the specifics of that.
Gotcha. And so I want to ask you a little more on that process. So let's say I have a campaign, I'm raising money. Over the course of the campaign, I've hired a new, somebody's coming into the company, and I have allocated some equity to them. Would that constitute material change, and would that necessitate the investors who have already committed to invest to opt in?
I know Peyton is going to say that's a legal question, but it's not an easy legal question. Material, my definition of material, and you should know material is a word that's used throughout the securities laws. It's like the word reasonable in tort law. It's just used everywhere. Material, what does material mean? Material means an average investor would think it's important. That's that's what I take it to mean. So you could have a new hire who comes in and receives, your CTO, and receives some stock options, and that's new. As a general matter, I would not do that as a material change, because a reasonable investor just doesn't care, a typical investor. On the other hand, you could get a really high profile person, a big name person coming, and that may be a material change, and certainly an important person leaving is a material change. The strange thing about the rule, so if there's any material change, all investment commitments are automatically canceled, and your 1,437 investors have to recommit. They have to go to their computer and click recommit to invest. So you've lost them all. And so it means that if suddenly we just got a $20 million government contract, is that a material change? It is. Absolutely material change. And what happens? All the commitments are canceled. So it's a strange rule, but it is definitely I know it when I see it kind of thing. And reasonable people, Jenny and I could easily think of hypotheticals where we would disagree about whether something was a material change.
Thank you, Mark. I had an experience of speaking to a founder who was raising money for a small business. They've raised a considerable amount, I think a couple $100,000. And he was telling me that they had a situation where towards the middle of the raise, they found out that they made a mistake in the financial models. And it was showing 10x what it was supposed to be showing. Would you see that as something that warrants recommitment?
Jenny, do you want to explain about that?
That's like an easy one, right? I mean,
yeah, that's easy.
you would definitely want to immediately disclose that. Another thing that is kind of related to this is giving updates. The SEC really likes you to give updates and new information, not out there on social media I mean, you can, but they would prefer that you do it on the platform. You know, the platforms they're required to have places where you can post updates and answer questions. So, you know, that's another thing to keep in mind is if there is anything new, even if you're not, you know, treating it as material, it's good to put it, you should post it there.
Right. Got it.
Jenny or Mark, would you guys clarify the difference between why an issuer would file an amendment or a CA versus a CU? I think that would be really helpful.
Go ahead, Jenny.
Oh God, I don't know. Remind me, what is a CU again? I don't remember.
So
Mark?
there's Mark, you can probably jump in. There's the amendment, right? If you've filed something with the SEC and you need to you've made a mistake and you need to update it, which would probably be a short-term issue versus the CU would be something that would be more down the road. Is that how you would interpret that, Mark?
I'm not sure, to tell you the truth.
I
But
thought
I'm going to
was
look.
something you file at the end. Oh, I know what it is. It's the progress update.
Yeah,
form.
that's what I thought, but
Yeah, it's not filed when you make a change to your
right.
your offering. It's something that's usually going to be filed by the platform, just as it's required to provide an update.
Yeah, an update on how you're offering, how much money you're raising.
Yeah. How your progress towards your goal.
And just to be clear, the CA is an amendment, but even that comes in two flavors. Like you can file an amendment that is not material. So on the form CA, there's a box to check, and you better check the right box. Like I had one recently, we filed a form CA just for a non-material change, and the Edgarizing company, that through no fault of theirs, but their default is to check that box that says it's material. And if we hadn't caught that, you know, all the investment commitments would have been canceled. So just more fun.
Well, we actually have a question from Jackie Logan. Does the portal have a role in determining what is material? So who makes the call?
No, portals should not be making that decision. I think they do. I think that in the world we live in, the big portals function in all kinds of ways that they shouldn't be functioning. They function as legal advisors, they function as investment advisors to both investors and to the issuers. They offer advice to issuers about what kind of security they should issue. You know, what the terms of the security should be. But the answer to your question is no. That is the issuer's decision. Now, if the portal, if it's, our CEO just left or we were just sued, the portal, it's not exactly the portal's decision, but if the issuer made what was clearly the wrong choice, then the portal would have the obligation to take down the offering because the issuer is no longer complying with Reg CF. But yeah, the extent that there's a judgment call there is definitely a legal judgment that the portal shouldn't be making. But it's a weird industry right now in many respects, and the portals, and I don't necessarily blame the portals because they're kind of being asked to do all these things. And the economics of the industry almost dictate that they do some of these things. But technically, no, they shouldn't do it.
Yeah, this is very pertinent to that example that I made earlier with that small business raise, because when I was speaking to, I was asking questions about, well, you know, what did you like working with that portal, and the feedback was that, well, this thing happened, they told us that, send us everything, we're going to review it and post it on the portal. They sent the financials, and the blame that the business owner was allocating was towards the portal, that they didn't check it, essentially, which to me doesn't sound quite right, because that would be a very high burden on the portal to check through all of your financials. But that's I guess that gets us to the question of issuer education as to where the responsibility sits. Thank you for all of the comments on this subject. This is I hope that this will be of value to folks listening. Now, one question I've had set aside here is leveraging influencers for crowdfunding campaigns. So influencer strategies have become fairly popular. I can imagine going to folks on Instagram that have 20,000 followers. It'd be interesting to hear your thoughts about how other people can promote your offering, and what disclaimers they should give in order to do that compliantly, and whether they can do that at all.
You ever heard of someone named Kim Kardashian?
Sure.
Yeah,
so
there was the huge case where she was, fined some millions of dollars, and there have been other celebrities. So there's a separate rule in securities laws about promoters needing to disclose when they are paid. So that's a big issue, and I will tell you, maybe I'll shut up, but I represent a lot of portals, and during the application period, FINRA cares about this question you're asking a great deal. They really worry about the role that influencers play. I think in large part because of those examples within the crypto space. Influencers really using their position of being famous for being famous to get small investors to make really bad investments. So they really do care about it. But Jenny, do you want to say something more about influencers?
Yeah, there is some language in the actual Reg CF rules about disclosing when people are paid to promote. I'm looking for it now. I'll have to find it, but
yeah, they have to be in the communications channel. If someone is being paid to promote the offering, the communication, if they post a comment, it has to say underneath paid promoter.
I just found it's
thinking about
section rule 205. You can compensate people to promote your offering through communication channels provided by an intermediary, but only if the person takes reasonable steps to ensure that they disclose the receipt of the compensation.
And then there's a separate issue about, because a lot of people think naturally, well, how much am I going to compensate this influencer? Well, the way it works is the influencer has a website, right? And they say, if you want to learn more about this company, click below. And it's the influencer's website. And so technologically, they're able to track which investors are coming through the influencer. And it just seems natural to say, I'll tell you what, we'll pay you 5% of what. Yeah. But that then, you can't do that. That implicates a separate set of securities law rules about broker dealers. So this is why FINRA cares so much. There are a lot of bad things that you can do with influencers. But I mean, it is legal. You can pay an influencer a flat $10,000, flat $10,000 promote your offering on,
Right.
on his or her channel.
And I'm glad you did bring that up. That's a huge issue that a lot of people don't realize, is that paying a success fee to someone for helping you raise money is not legal unless that person is a licensed broker dealer. There are a few minor exceptions to that. So many people don't know that and get into those kinds of relationships. So you really want to avoid that. And I know the SEC has been trying to create rules around finders to kind of make that a little bit more reasonable, but it's, you know, it's been on their docket for like 30 years to create a rule about that. Maybe not 30. I'm not that old, but I think it might be 30.
I've almost walked into, like, at one point I was doing fundraising consulting, and I walked into situations where that was the offer, and you know, the business owner doesn't know what
Right.
that they're doing something wrong. I don't know that I'm doing something wrong.
Yeah.
Like,
Often the finder is the person who's making the offer to do it. They don't have any idea that what they're offering to do is illegal. So yeah, it's a mess.
Well, and in fact, not only do they not do it, but one of the reasons this area is so infuriating is that there are tons of folks out there who are doing it and have been doing it for 30 years and have never gotten in trouble. It's hard to be a lawyer in this area, to tell you the truth, because you tell your client, oh, you can't do that, and they say, what are you talking about? I know 6 people who have done this successfully. And this is why the SEC, it was a few years ago, they came out with a proposal that hasn't been adopted to sort of standardize and legalize the finder community. But people do it all the time. In real estate, it's almost, that's what makes the wheels turn out there. It's very, very common and illegal. So what can you say? But for the purpose of this internationally televised show, don't pay commissions. Just adopt that as your rule. I'm not going to pay commissions to anybody except to the portal, because they're allowed to receive them.
yeah. The question is, are you, you know, if somebody offers you that for, you know, to raise with a success fee, ask if they're a broker dealer. All right, well, folks, we have about 12 minutes left, and there's this entire section of questions that I have for investor relations. So let's assume that the business owner has finished their campaign, raised the money that they're looking for, they're off to the races to use the money. Question number 1, how does the campaign closure go? Like, what are the actual things that happen once you close the campaign, and how do you action that?
I mean, you just take the money. Technically, at that point, the funding portal directs the escrow agent to deliver the money to the issuer and deliver the securities to the investors, and the offering is now complete. That's what happened.
All right. And then I guess that's this is more intuitive than other questions. And then the second question is, well, investor reporting, right? So my understanding is that the risks to not executing investor reporting right are fairly high. And so it would be great to hear your thoughts on what are the, you know, what are the standards for reporting to investors after you've raised money from them with crowdfunding, and when might you be in violation, and what are the risks?
Well, why don't we let Peyton talk about the Form CAR? Because I know that.
Sure. Yeah. So we work with people for Form CAR, which is the annual report, which has its own set of rules on whether or not you need to file it. There's a minimum of 1 that needs to be filed after you have sold securities in a campaign. And and then based on the number of investors that invested in your campaign and amounts you in the future at a point are able to file a form CTR, which terminates your obligation of reporting. We encourage people to do annual reports whether or not they've met those requirements, because it is good practice to keep your investors updated. You know, there are different requirements for corporations and other ways, but I think as far as the Reg CF goes, it's a really important to give an update annually. And a lot of people don't realize that they have to do it. And so it's interesting talking to founders a year later. A lot of them may be disheartened from the experience that they had raising on different platforms, and maybe they didn't get the money that they were hoping for, and now they have to output another several $1,000s for this annual report. So it's a very interesting interaction to have with founders. And I think we always try to use that to then go back to the beginning, right? And that education piece and that hand-holding piece, and really setting an expectation of, this is not just an easy thing. So before you commit to it, make sure that you understand that you want to finish tying the bow and make it look pretty, because it's important energetically, right? Just for the company, setting the energy of the company, the future, all of those things. So we offer the CAR. We like to say we offer a tool that's as easy as possible. It's not as complex as the Form C, but it is still fairly complex. And it's very important that founders make those material updates and changes in the CAR before they file it.
Do you folks do a Form CAR even if you didn't do the original Form C?
Yes, we do. We basically
okay,
we take everything that we can from our paralegal side to help people to populate that into the draft. And then the responsibility goes to the founder to read through that all, to make the updates, to get their US GAAP financials up to date, and to kind of make sure everything looks good. And then we offer a securities attorney review on that CAR as well before it's filed.
And so many people don't really realize that they do have to do those GAAP financials.
Mm-hmm.
A rude awakening when they figure that out.
Yes, definitely.
So in terms of the actions that the founders take when they're filing the Form CAR, do they do that, 365 days after the end of the campaign, or at the beginning of the campaign, or?
Yeah, that's a great question, Peter. It's so it's 120 days after the end of their fiscal year. So for most companies, that ends up being April 30th, but that's if your fiscal year ends 12/31. So I would say the majority of, oh, go ahead.
The fiscal year in which the offering ended, right? So if you start an offering in November and it finishes in January, you file the annual report by April 30th of the following year, right?
Correct.
Okay.
Got it. I got distracted, Peyton, by your gigantic cup with your name on.
Oh, I know everyone. I drink so much water. My background is in wellness, so I drink a lot of water. And I've been recently made a lot of fun of for my water container. What else was I going to share on
my background is in wellness.
So. You're drinking coffee.
And Starbucks, of course.
So, okay, Peyton, you were going to say like may there be something else that's important to mention to folks?
I can't remember it off the top of my head.
I got some more questions here.
Yeah, well, go on. Move on to another.
Let me just say, you had asked about the penalty. What happens if you don't file?
Yeah, that's good.
You can't, if you don't file, then you can't use Reg CF anymore until you do file. So if you forget to file and then decide a couple years later, I think you can go back and file the Form AR, and now you can file for Reg CF again. But
also, Reg A is impacted.
Is it? Does it say that you can't raise money in Reg A? Okay.
It is. And we get a lot of people coming in at the last minute to file by the deadline, and then they get really concerned if their financials aren't ready. And we share that, we haven't seen any action taken on a late filing. So it's better to file late than to not file at all. We definitely emphasize that as well.
Got it. So these are the practices that, you must do, right? Yeah, you can be late, but still, it's a good thing to file to inform your investors about what's going on and to file Form CAR. I wanted to ask you about the general kind of like best practice recommendations for informing your investors as to what the hell is going on with your company continuously over the course of the year, right? Not once a year hear from us, but more regularly. If you could share, I understand that this might be a little bit outside of the practice of the law, but I'm sure that you've seen, good practices and bad practices in investor reporting. So
I have a huge pet peeve on that topic, and that is that the platforms, a lot of them have started kind of trying to take over that role. And that is not good. You are the issuer, you are the company. You should not be relying on some platform that may or may not be doing things correctly, might go out of business, and we could talk all about the whole thing of if they go out of business and their SPV disappears and all that. So I think there's a big over reliance for so many things on the platforms. And so if the platform is going to send out stuff on your behalf, okay, but don't give up your knowledge and your control of all those things, and also do your own, have that list of investors, communicate with them, keep them, aware of what's going on. If you just totally forget about it and leave it up to the platform, and then 2 years later, that platform goes out of business or gets shut down by the SEC because the majority of them are breaking the law half the time, you will be so sorry. So just forget the platform even exists, let them do what they're going to do and take responsibility for communicating with your investors, filing the reports you need to file, which hopefully you maybe only will need to file that one, but
now here's
send
the
them their K1s, right? Send them their tax stuff. Make sure
here's
that's
the flip side of that. The platforms, I represent a lot of platforms, and what happens on the platforms is issuers come on the platform, raise money, and then don't communicate with their investors. So the platform says, what can we do? This is terrible for our reputation. A developer came on and this project is going sideways and they're not giving anyone any information, and that's bad for us. So
true.
Representing platforms, I try to make the issuer send information. But to answer the question that started out, best practice, I don't know there's any specific best practice. Communication in relationships is always a good thing. And
we'll take it to all parts of our lives.
Exactly.
But we have 1 minute left.
Start sending annual emails to your wife or husband to communicate. But that's all you have to do as a developer, basically. Communicate.
I'll tell my romantic partners once a year. All right. Well, we have 1 minute left. I see the flashlight blinking in the chat from Devin. Thank you so much, Jenny, Peyton, Mark. It's been fantastic speaking to you. All of the members of the audience, please follow, the members of the CfPA and this panel on LinkedIn, on other sources, wherever they are. And I hope that you've gotten value out of this conversation. I guess if this doesn't shut down automatically, then I'll give the panelists an opportunity to say a few last words about what they would like to, impress upon the future business owners raising money with crowdfunding.
I have to jump on another call, but thank you so much. This was awesome.
Bye, Jenny.
Thank you, folks. Thanks, everyone. Bye-bye.
Yeah, thanks so much.
Bye, everyone. Thank you.